Okay, we are back, and we're going to be talking about union visibility in the workplace and the importance of making the union strong. Another area that you have to worry about as a steward is union visibility. What can you wear? Buttons, badges, caps. And again, these are sections of a contract that allow the company to the emblem on your uniform. It may be a patch, it may be a pin. We have some locals which will pay, or which the employer pays, to have badges sewn on the jackets of the members. And this is very, very important because union visibility across the country is down. People don't wear their union uniforms and their union badges around. One of my pet dreams is that every union member would have a yard sign in front of his or her house saying "Proud Union Member." And I just was in a supermarket yesterday, and a guy was in front of me with a Teamster Union t-shirt on, and immediately we started talking about unionism, about pensions, about grievances, about conditions. And that's the kind of visibility that we need to have. We need to have it as we drive the buses so the public knows that they are beneficiaries of the ATU. And so that when we go to them for help as riders, as voters, as taxpayers, they will recognize the union and its importance. This is another area of your contract which is very important, the just cause. And again, as I said, this represents a huge difference from the non-union workplace. And it needs to be clearly explained to all your members, and it needs to be particularly explained to new hires who have never experienced such production and who may think they have died and gone to heaven, where the boss cannot come around and because he doesn't like you, or bad reason, good reason, or no reason, fires you. This is an area which we see is about 75% of our grievances. It has to do with discipline, and you need to know what it is. So you need to look at this document, the 7 tests for just cause, because this will give you guidance on what you can do and what you have to provide for an employer to discipline somebody successfully. You also need to look at the document off-duty conduct disciplines, because this is a growing area. Once upon a time, there was a clear line between your work and your personal life. And what you did in your personal life had no impact on your job. Those days have changed. And it's particularly changed in industries like transportation, where the employees have a relationship with the public. And so the standards which are used for their behavior can be higher. But we've seen some flukes. I had in a steward training class last week a situation in which a member of the union in Florida is provided a company shirt and company shorts while they're driving, and they're clearly marked as the company's. This member went into a bar, took off the company shirt, put on his own shirt, went in the bar, and was seen on a surveillance camera with the employer's shorts on, and the company tried to discipline him for it. So these are the kinds of things that you're going to see. This is also important for areas of social media. What can you post on the Facebook about your employer, about your job, and about your coworkers? And again, this is a whole course in itself about just cause, but I just want to call your attention to it as an important article of the contract. One of the very important parts of the contract in this just cause is that somehow people think because you can't file a grievance for the discharge of a probationary person that the union, quote, can't do anything for new hires. This is just not true. You may file grievances for new hires on any topic, and a new hire gains the benefit of the union the first second he or she hits that time clock. because all other areas of the contract apply. And what you want to do is read the article carefully, protections during probation, because this will spell it out. But it's very, very important because as you sign up new members, they will often say to you, what am I going to get for my money? And this article will help answer that. But again, it's an example of how the steward is an organizer. And understanding the contract and how it applies to everybody will help you build the union. Another area which is very important and is often overlooked as a steward's guide is health and safety. And here again, read the article when a job affects a member's health, because you will have language like this in a contract, but you need to be proactive. And we have said to stewards that there are two types of grievances, proactive and reactive. And the reactive is when a member comes to you with a problem and says, I think I got screwed, can you help? Proactive means you go look for situations, and there's nothing more important than health and safety. And the ATU magazine and the ATU website now has enormous amounts of new material on health and safety, on rest breaks, on fumes in the garage. One of the things which recently was in the magazine was about mental health. And the rate of depression among drivers is higher than any other occupation. And these are things that we would never think of as being responsibility of the steward. But the health, the welfare, the safety of your members is number one on your list. And again, you need to stay active in learning about this material. You need to watch for it and not be bashful, because there is nothing worse than seeing, for example, a tolerance for bad safety conditions causing a serious accident. And it means using your responsibilities and your power as a steward to instruct new members and to force the company to provide a safe and healthy workplace. So those are the important areas of the contract. And what we're going to do when we come back after you finish reading those articles and had a break, we're going to look at the grievance procedure itself. All right, we have looked at the other important articles of your contract, but this one is central for every steward and officer. It is the grievance procedure. It is one way in which you try to resolve problems in your workplace, and you gotta know it. And I'm particularly telling this to your new stewards. You need to read the documents, the grievance overview and the grievance procedure. Because one of the things which is very important is the vocabulary of grievances. You need to know the expression time limits. You need to know the appeal process, who gets what step of the grievance, who participates in it, and you need to understand your union structure, because decisions about what to do with grievances are not yours alone as a steward. So read these two documents, the grievance overview and the grievance procedure, before we go to the next slide. As I said, in the grievance overview, you will see a list of vocabulary, because the grievance handling, your steward's work, is like any other area. It has its own vocabulary. Public transit, driving a bus, maintaining a bus, has a whole list of vocabulary that you have to learn. And so this is a new vocabulary. And you as an officer or steward have to be precise about what you're using. And some of these terms may be familiar to you. You may have heard them, you may have used them, you also may have misused them. But we all need to be speaking the same language. A grievance. And a grievance is formed under the contract. You can have an individual grievance. That is, it is in behalf of an individual member or non-member in an open shop state. It can be a discharge, it can be a failure to pay overtime, it can be a failure to promote, it can be all kinds of things in which one person is the object of the grievance. One of the things I will stress to you, however, as you communicate grievances to your members, emphasize that by defending an individual, even an unpopular one, you are defending not just the individual, but all members of the union and the union contract. Because if you let the boss get away with something on one person, he's going to want to do it on all of you. And so defending the contract is very, very important. You can have a group grievance, and a group grievance is a great organizing tactic. And what it means is that some situation at work affects a lot of people. Historically, what happens is the steward will file a grievance in behalf of those individuals. What I'm going to encourage you to do in the areas of organizing around grievances is have every one of your members and non-members sign it. For example, if you have a ventilation problem in the garage, yes, you as a steward could file it, but it affects dozens of members, and so they all need to do it. You can have a union or policy grievance, that is, the company does something which affects everybody, and so the union is responsible for it. We're going to talk about a fact sheet, and a fact sheet is absolutely essential. And when I was representing locals, I made sure that every steward filled out a fact sheet before we would accept a grievance discussion. Steps and time limits. You need to know what are the steps of a grievance procedure. They're clearly spelled out. Step 1, Step 2, Step 3, depending on how far it can go. And time limits. And time limits are when you have to file initially, when you have to file an appeal. And you need to know what these time limits are, because if you miss your time limits, your employer may deny the grievance, not on the merits of the grievance, but on a procedural issue that you have missed the time limit. You need to know what a remedy is, and a remedy is what you want the company to do or the employer to do to make the grievance right. And you have to spell it out, and we'll be talking about this in some detail. A settlement. And a settlement is something which is less than the union wanted as a remedy, but it is still acceptable. Most commonly is where a company wants to fire somebody, the union makes a strong case in a grievance, and the company says, okay, we'll bring him back, but we want to give him a 3-day suspension or something like that. And we'll talk about the controversies and the authority of the union to take these grievances and settlements and what you can do. A reactive grievance we've talked about before, and that is when some member comes to you and says, here is a problem. A proactive grievance is one where you as a steward go around and look to see what conditions need to be improved. One of the most common mistakes, often spread by supervisors, is that it's illegal for a union officer or a steward to solicit grievances, that is, to go around and ask people, how are things, are there any problems that I need to look at? This is an absolute lie. You have a total right, legally and under the contract, to go around and talk to your members and see if there are things that are bothering them and that you may need to create as a grievance. A divisive grievance. A divisive grievance is one which pits members against each other. You can have an individual grievance, for example, where employee A bids on a higher rated job and gets it. But employee B says, I have more seniority and equal qualifications. And they want the union to file a grievance in their behalf and take employee A out of the job and give it to employee B. And both employee A and employee B have all kinds of friends in the shop, and it becomes very, very complicated. We're going to look at organizing around grievances, and we're going to spend a whole lesson on this later on, but it means bringing your members into leverage to help you win those grievances, making it a public issue, even spreading it out to your riders, to the communities, if it's something which is important enough, like a health and safety grievance or a change in ownership or subcontract or something like that. And finally, Weingarten Rights. And Weingarten Rights is a legal term, but we're going to show you how to expand that. and that is the right of a member to be represented in any disciplinary investigation by their steward. So, if you look at your sheets, here are 5 different grievances. A violation of a union contract, a violation of past practice, a violation of any relevant law, a violation by management of its own policies, and one that I have always added, just plain unfair. So let's look at each of these and see what we're talking about. The violation of the contract can be very simple, or it can be very complicated, as you know. But you have to know the contract. And if you're a new steward, take some time the next day or so to go through every article of the contract. Make notes, highlight it, mark it. And if there are things that you don't understand in that contract, go ask some more experienced steward, because you gotta know it. And you'll be surprised what little corners and areas you can find that will be helpful to you down the road. So you got to know it. You read this, what's in a union contract. I also have an article called the Peskies. And the Peskies are words which are going to give you problems. And they are words that you'll see highlighted here. You may wish to go through your contract when possible, or where practical, or make every effort, or as we saw in this previous discussions about union activities, in an emergency situation. There are lots of words that you can't define. What's reasonable? What is just cause? Did the company make every effort? And again, this is an area where you defend the line of scrimmage. Leverage that you have as a good steward will help you convince the company or your employer it is now possible and it is now practical to deal with the situations as we want to do it. You will also want to look, as you go through your grievances, at changing language in your contract. Because the contract which says the company may do something, you want to change that to the company must do or shall do. Because just that small change takes away that power and that discretion from them. A past practice is any long-standing practice that is accepted by both management and union. These are not in the contract, but they're considered part of the contract, so a grievance can be filed by the management if management violates them. So be sure to check your contract for any language that may limit their use, but you look at what is a past practice. It must exist for a reasonably long time. And what is a reasonably long time? I always tell my stewards, if it happened more than once, that's a reasonably long time. And again, these are areas where leverage is important. It's occurred repeatedly. It's clear and consistent. It must be known by both management and the union. That is, it's not something that you've hidden. Working on your own vehicle, for example, with some company tools in the yard. If it's been done and then the company says we're going to stop it, you then have a right to grieve that under the past practice clause. There are 2 very good articles. Joe Twarog, if you may have seen him teaching at the ATU Douglas Center, and one by James Gallagher on past practice grievances. So read those and understand them. A violation of the law. And a violation of the law may overlap your union contract, so you may get a double shot at your boss, but you need to understand the situation in your workplace. You need to understand the possibilities about the grievance procedure or a workplace action, and then look at all the language. There's so many laws. There are federal laws, there are state laws, provincial laws, local laws, and they change constantly. So you really need to find a labor law class or to find a way to keep up on what the laws are that affect us in the workplace. You can also check out a project I did on workplace rights, which has video presentations on the most important laws in the United States, references to discussions about them, and discussion boards. Because one of the questions that's going to come up for someone who feels they've been discriminated against, for example, you have a federal law, you have a state law in many states, and you have the non-discrimination clause of your contract. So if you have a woman, for example, or an African-American woman, or a disabled person who feels that they were denied a promotion because of their race, or their disability, or their sex, or their sexual preference, or any of the areas that are covered both by the law and by your contract, you have several directions you can go. You're at a crossroads, and you need to be able to advise your members of what's the best place to go and how the best place to do. You need to look at articles of your contract which deal with the situation. You need to know what laws might also apply. And I would suggest if you have public agencies, federal agency in the United States, the Equal Opportunity Employment Commission, you may have a state Human Relations Commission, you can call them and there's no cost. One of the dangers is that if you start talking to your union lawyer right away or another lawyer, they see a potential fee and may encourage the person to file a lawsuit rather than following the grievance procedure. You want to look at what remedies are available by law or as a result of a grievance. And one of the issues is that in a grievance, you can only ask as a remedy for actual losses. For example, if a woman is denied promotion to be a mechanic, and it takes you 6 months for her to win the case and to prove that the supervisor who said, "I'll never have them girls working for me," was guilty of sex discrimination under the contract. She can collect only the money that she would have gotten if she had been working that job. And that includes overtime, that includes tool allowances, that includes any other benefit. If you sue, you can also collect damages. We have seen this week a woman, for example, filing a sexual harassment lawsuit against Fox News, collected $20 million. Now this is an extreme case, but it's certainly a lot more than you're going to get in a grievance. On the other hand, how long is the process? A grievance process is direct and gets the member into the issue quickly. A court case, if you sue, can take years. What expenses involved? If a member feels that they have been discriminated against, for example, the union takes the case on, and there is no expense to the member. If the member thinks about suing, my experience has been that there are very few lawyers who will take on these kinds of discrimination cases, for example, because the time limit is so long, and they will then ask for $3,000, $4,000, $5,000 up front as a retainer. And in effect, it discourages people from using legal procedures. In the United States, the EEOC will take some cases, but often will simply investigate a situation, and if it's not a particularly precedent-setting case, will give you what is called a right to sue letter, which means you can go hire your own lawyer and try and get to court. And so these are the risks and the hazards that your member may encounter. One of the values of filing it as a grievance is that then they are protected by the non-discrimination clause of the contract for union activities. And often what will happen is if a member files a grievance for discrimination, for example, a supervisor will then find other things to punish them. Look at their attendance, will look at their work schedules, will look at anything else that they're doing. And if it's a grievance, the union is there to protect them in every one of those cases, which is very, very important. A lawyer can't do that. So what you need to look at is, can you use both a grievance and a legal issue? Which one do you want to do? Which is going to be the best for the member? And what you need to do as a steward is sit down with your members and with your officers and clearly explain all the different things that can be done. Because your member has to understand that they think going to court is something that's can be done in 2 weeks with no expense and they can't lose. And they need to clearly understand that's not the way the world is set up. Another part of a grievance is a violation by management of its own policies. Often the company will publish a list of policies and post it, and everyone is expected to accept it. But they usually will often discipline us and let the supervisors slide. For example, I've had grievances recently over language in the workplace. And we hear supervisors coming in and using the F word on a regular basis. But if one of the members does it, and particularly one of the female members, they then want to write them up as a violation. As a steward, you need to take a time to look at these situations. And so if our employer tries to discipline one of our members, we can prove unfair or what's called disparate treatment. And disparate treatment is a grievance term that's on your list, and it means treating one person one way and another person another way. And it's very, very important that the union eliminates favoritism. That's the whole purpose of the contract. And that is the whole difference between a non-union workplace. And finally, and this is something which many steward classes challenge. If you go to a normal steward training class, they will say, well, you have to understand the difference between a grievance and a gripe. And they're very conservative, and they say a grievance is something which is clearly spelled out of the contract. A gripe is just something your members complain about. Well, I'm going to tell you that just plain unfair is one of the most important potential grievances you can have. And it starts as a gripe. And it's a complaint by one of your members about some condition in the workplace. And it may be something new, it may be something that they're suddenly aware of, it could be anything. But if it's some situation that gets them angry, you need to look at it and see if you can't file a grievance on it. If nothing else, you can use the recognition clause because it is a term and condition of employment. And if nothing else, sitting with your members and listening to them articulate what is bothering them about the workplace is very, very important. It builds the union, it increases your role as a steward, and makes them feel that they are part of a strong ATU local. So I want you to read particularly that article, A New Look at Grievances, because it will show you how you can use the kinds of complaints that many steward classes ignore to build the union. And finally, the Weingarten Rights. And this is one of the most misunderstood terms in steward training. Again, often locals will pass out a Weingarten card, and you'll see it here on your screen, and it goes back in terms of 50 years to the original Weingarten Supreme Court case. I'm going to tell you that, and you're going to look at the article, No Investigation Without Representation and Weingarten, to see what I'm talking about. My recommendation is that any time a member goes in to talk to a supervisor, you as a steward need to be there. And they may be talking about something which is inconsequential, maybe questions about why I didn't get paid this week or something which seems to be a casual kind of discussion. But if it involves a term and condition in the workplace, it is a union issue, and you as the steward need to be there. You need to be there because you can advise your member about what the terms and conditions of the contract are, and they may not know. You can be there to keep your member from answering questions that may get them in trouble. And one of the things which I have found very important is that if there is a controversial issue between a supervisor, for example, and one of your members, and the member goes in alone to discuss it with the supervisor may use this as an opportunity to turn the situation. And what I've had is supervisors who come out of an office with a member and say, this guy threatened me. He threatened my family. He says I know where I live. And the member did none of that. But suddenly the issue has changed from whether or not employee A is entitled to overtime to whether employee A threatened the supervisor and is guilty of possible workplace violence. You as a steward could have been a witness to this and would be able to disprove whatever the supervisor claims. So expand the rights. Do not allow a member to go in without you or someone from the union being there. Even if it means waiting a couple hours. Under the law and under the contract, you have that right. So this finishes our discussions in session 4. What I want you to do is to write up which article of the contract has had the greatest effect for you. And that'll get you thinking about the articles of the contract that you have done before. And then I want you to go listen to one of the most wonderful labor songs sung by the great Paul Robeson, Joe Hill. We're going to take a break here, but I want you to go back and review the documents on the grievance overview and the grievance procedure and look at these vocabulary terms in your own contract.